Hi everyone, I'm attorney Aiden Kramer with the Law Office of Aiden Kramer in Colorado, and you're watching All Up in Your Business. In this episode of All Up in Your Business, I'm going to talk about how to get a trademark. I've made videos in the past talking about the basics of trademarks and when you should get a trademark, but in this episode I want to walk you through the actual process of obtaining a federally registered trademark. The first step in getting a trademark is before you do anything, before you start filling out any paperwork, do a search on the USPTO's website. That's the U.S. Patent and Trademarks website. They have a search function, so you can search registered trademarks, pending registrations, to see if there are any that are similar or identical to your trademark. I strongly encourage you to not do this by yourself and to instead have an attorney help you with the search process, because as easy and straightforward as it might look, it is very not that way. When you're searching to see if your trademark is available, you can't just search for the exact wording of your trademark. If you have a slogan or a business name that you want to trademark, you can't just type that in, see if something comes up, and if not, yay, you're great. That's not how trademarks work. You need to search for variations of the words that you're going to be using in your trademark. You need to search for similar words or similar trademarks. So just because you don't see your exact business name somewhere already being registered as a trademark does not mean that you're going to skate through the trademark process easy. Once you've searched and you're fairly confident that your trademark is unique enough that it's going to be registered, then you move on to filling out the application. There is a version of the trademark application available on the USPTO's website, and you can do it all through that website. The USPTO's website, where all of this is done, is uspto.gov. When you're filing the application's going to have a few requirements. First, obviously, it asks for your information or the information of whoever the owner of the trademark is going to be. So you put that all in, and it's also going to ask for information about the trademark itself. If you are trying to trademark just words, a business name, a slogan, something like that, not a logo, then you enter that in where it asks. You enter in the literal element of the trademark. But if you are trademarking a logo or some other stylized design of your business name, then you're also going to have to describe in very detailed ways the elements of your logo. You need to describe exactly what it looks like, different parts of the logo, the colors that are used, all of that. So you need to be very detailed when you're filling in that information about your logo if you're trademarking a logo. The application is also going to ask for a specimen. Now, this is where a lot of people get tripped up and don't use the right thing. A specimen is something that shows the USPTO that you are actively using this trademark in commerce. So you can't just, if you're trademarking a logo, you can't just upload a photo of your logo and use that as the specimen. That is not going to work. You need to somehow show that your logo or your business name is being used in connection with certain goods or services. What I typically do, and what works best usually for services, not always for goods, but sometimes what I often do is upload a screenshot or a printout of the company's website. So that shows the company's name or the company's logo, and the USPTO can see that the logo or the company name is being used in connection with the company's services. So that way the USPTO knows that this trademark is actually being used and being marketed in connection with the business's business. So that brings me to the next step, which is going to be picking a class of goods or services. When you file for a trademark registration, you file it in a specific class of goods or services. You can file it in just one class, or you can file in multiple classes. The application fee, though, is per class, so just be aware that if you want to get a trademark in multiple classes, you're going to have to pay more than one registration application fee. When determining which class of goods or services you want your trademark to be registered in, you want to pick something that obviously describes the nature of your service or your goods that your business is providing. So for example, if a law office was going to get a trademark for their logo, their class would be something related to legal services or legal consulting, something like that. If you're selling apparel, then you would want to pick a class that describes apparel. So once you get through the application and you submit it to the USPTO and pay the application fee, you then wait. And you wait a little longer. And then, typically in about 3 months from when you file the application, you'll finally get some sort of communication from the USPTO. In many cases, the communication that you're going to get is an office action. The office action may be a non-substantive office action, something such as wanting you to disclaim a certain word or element of your trademark, or it will be a substantive office action, which is a bit more difficult. In these types of office actions, it's going to take some work because typically the USPTO has found some reason why your trademark should not be registered. The USPTO gives you 6 months to respond to the office action, and it's almost always in your best interest, if you haven't already, to immediately contact a lawyer to help you with responding to those office actions, because the response can sometimes be very difficult and takes a lot of legal research and writing knowledge to properly respond to them. If you do get an office action and you respond to it, or if you don't get an office action, then again, you'll wait a little longer. A few months later, the USPTO is going to let you know that they've published your trademark for opposition. It's kind of like when you're at a wedding and the officiant says, if there's any reason why these two shouldn't be married, speak now or forever hold your peace. That's exactly what the opposition, publish for opposition, is like. The trademark office gives everybody else an opportunity to oppose your trademark before it's registered. And if they miss that opportunity, then there's still ways around it, but they, for the most part, missed it. If your trademark goes through that publication period, then a few months later, your trademark should be registered and you'll have a formal federal registered trademark. So typically the process takes anywhere from 8 to 12 months, if not longer. If everything goes through smoothly and there are no office actions, no one opposes the trademark, then it's a relatively quicker process. But if there are office actions or more issues come up, it can take well over a year. But a lot of that time is honestly just you sitting, waiting to hear something from the trademark office. So as I mentioned, it's really almost always not a good idea to try to register a trademark on your own. It's complicated and it can be very difficult, and because of that, it's worth the money to hire an attorney to help you with the process. I've worked with several clients on trademark applications, and even I still sometimes get stumped because new things will pop up with new applications that I haven't experienced before. So just because the application looks easy doesn't mean that the process is easy. If you are looking for assistance to get your trademark registered, I, of course, am available to help. Thank you all so much for watching. I'm Aiden Kramer, and I'll see you next time.